Welcome to the Docketing Excellence webinar series.
Welcome to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm and Black Hills IP to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. To listen to one of our many past webinars or to register for future webinars, go to the Docketing Excellence Series tab on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today, I think, is the 20th in our overall series and is focused on the topic of docketing response dates in countries that have acceptance deadlines. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your, questions can be submitted using the Q&A button on your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. Before I begin, I want to let people know that Black Hills IP is presenting a free full-day docketing seminar on September 7th in Chicago, and then again on November 8th in Washington, D.C. The content of these seminars is different than the content of the webinars, so if you've listened to our full webinar series, this will not be a repeat of the webinars. The seminars are an interactive workshop that have something to offer for all levels of experience, including very experienced docketers. To register for one of the seminars, go to the Docketing Excellence Series tab on our website. The presenters today are myself and Chris Rudebish. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center in Concord, New Hampshire for 5 years. Chris, tell us about yourself.
Yes, thanks, Sue. Hi, I'm Chris. I'm currently a foreign filing paralegal at Schwegman. I have been with them for almost 10 years. Over the 10 years, I've been a U.S. paralegal, a case management representative in the foreign department, as well as working in the docketing department.
So you've got all the different perspectives. Thank you very much for talking with us today.
Absolutely.
So today we're going to talk about, first, what is an acceptance deadline? Second, what countries have acceptance deadlines? And third, how do you docket the acceptance deadline in each of those countries? So first, please take a moment. There's a poll in front of you with a list of different countries. If that country has an acceptance deadline, indicate yes. If it does not have an acceptance deadline, indicate no. And I'm going to give everybody about 30 seconds here to complete the poll before we go on to the next slide. So I'll give you just a few seconds here. Go through and indicate which countries you think have acceptance deadlines and which ones you don't. Because I will say that as I was preparing for this program, I thought acceptance deadlines are pretty straightforward, and I thought I knew all the countries that had them, and I realized that acceptance deadlines are a little trickier than I had previously thought, and I learned of a couple countries that had them that I didn't previously know. So let's see how you guys do. Okay, let's hopefully everybody's got their responses in there. And as soon, there we go. All right, first, what is an acceptance deadline? An acceptance deadline is a date by which the patent application must be accepted, or in other words, must be allowed or in condition for allowance. If the application is not in condition for allowance by that particular acceptance deadline, you usually have to do something like file a divisional application to keep the application alive. Now, filing divisional applications adds to the cost, and sometimes that also just overall delays the process. So that's not something you want to have to do. You don't want to find yourself in the position of having to file a last-minute deadline or file a last-minute provisional because you didn't have your application in condition for acceptance. But acceptance deadlines are tricky to docket for a number of reasons. First, a lot of people don't understand the nature of acceptance deadlines and how they work, or certain best practices that are good for docketers, like docketing a reminder prior to the acceptance deadline, which we'll talk about. So just a little bit more, though, about the difference between a straightforward response deadline and an acceptance deadline. If you think about countries that have examination reports or office actions and that specify in those office actions or examination reports a due date, the docketing is generally pretty straightforward. You have a response deadline that's calculated off of a mailing date, and that deadline is either extendable or non-extendable. If it's extendable, you also docket the extensions and the final deadline. And that's it. That's pretty straightforward from a docketing standpoint. Acceptance deadlines are a little bit different in that the response deadline is not just when you have to respond by, but within that period of time, you also have to allow time for the examiner to review your response and subsequently either accept it, or if they don't accept it, issue another examination report, and then you respond. There's a number of things that have to happen, intermediate deadlines, so to speak, all that have to happen before that date that you've docketed as the acceptance deadline. So unlike response deadlines, attorneys really have to plan ahead with acceptance deadlines. With response deadlines, attorneys can wait till the day before sometimes and file a response and everything's still fine. Mm-hmm. You can't do that with an acceptance deadline. So how can docketing help attorneys plan ahead? What can the docketers or the paralegals do? One thing that we recommend in some situations, and we'll talk about it as we go through this program, is to docket a series of reminders so that the attorney has time to file at least one response well in advance of the acceptance deadline. But when do you do that? How far in advance do you do that? We'll give some examples as we go through this program. All right, next I want to see how we did with determining which countries have acceptance deadlines and which ones do not. Most people, actually everybody who took the poll said Australia has an acceptance deadline. So everybody got that one right. That's correct. Most people said Canada does not, and that's correct. Canada does not. People are a little confused on India. Some said, 47% said India has one, 53% said that it does not. In fact, India does have an acceptance deadline. Mm-hmm. Most people said Italy does not, and that is correct. Most people said Mexico does not, and that is correct. 80% of people said New Zealand does, and they are correct. New Zealand has an acceptance deadline, and we'll talk about that today. People were unsure about Singapore. 41% said yes, 59% said no. In fact, Singapore does not. Now, Singapore is tricky to docket in and of itself, but mm-hmm. they do not have an acceptance deadline. A little less sure about South Africa. 62% said South Africa does not, but in fact, South Africa does have an acceptance deadline. That was one that I didn't know prior to this program. And most people said Taiwan does not. That's correct. And then 71% of people said the UK does not. And that was another one that I was unaware of. That's a tricky one. The UK, if you're filing direct in the UK Patent Office, does have an acceptance deadline. So the 5 countries that have acceptance deadlines are Australia, New Zealand, South Africa, India, and UK. So we will talk about each one of those now, and we'll start off with Chris, and the one that everybody got right, the most well-known one, which is Australia.
Yes, thank you. So the time period for acceptance in Australia is 12 months, which is based off the examination report mailing date. It is a non-extendable date. If you don't have your application in order for acceptance, it will be abandoned. If you come to that point where the application is not accepted and you are at the acceptance deadline, it's a good idea to file a divisional application if you wish to pursue that application. Some docketing tips. It would be a good idea to docket a reminder for sending amendment instructions to the associate at least 1 month from the date of the examination report, and hopefully it will continue to roll month to month, so you get that reminder every month. It's also good to have that just because, like Anne was saying earlier, that you can communicate with the Australian Patent Office as many times as you can between that, first examination report and that acceptance date to get it allowed. So that's another good reason to make sure you get those reminders docketed as soon as possible. It's also a good idea to docket the acceptance due and a divisional deadline for the same date. And then for any subsequent examination received after that, docket it the same way with the reminders.
Now, Chris, for some reason, I used to think Australia had 21 months for the acceptance period.
Yep.
Did they used to, and that's changed?
Yes, exactly.
Okay. So if you haven't worked with anything in Australia for a while, you don't have as long as you used to have. You now only have 12 months, and I think that changed, well, it's not that recent, but it changed around 2013.
Mm-hmm.
So the acceptance period is 12 months, not 21 months if you had that old date in your system or in your head.
Yeah, exactly.
Now, how often is it, in your experience, Chris, that you wind up filing a divisional because you get to the end of the acceptance period and you don't have it in condition for allowance?
I haven't had it happen too often. I see more of it getting allowed by the acceptance date, just because with that, going back to that docket reminder to send the instructions, if you, start harping on your attorney right away, then, you can help them get it going. So hopefully you don't have to wait till that last date to then file a divisional. So.
Okay, so you get them to plan ahead.
Yeah.
All right, now talk about New Zealand.
Okay, so for New Zealand, there are many similarities between Australia and New Zealand, such as New Zealand also is a 12-month deadline date for acceptance based on the first examination report mailing date, and the acceptance period is not extendable. The biggest difference is when you receive that first examination report, the examiner will also give you a response deadline that you have to respond by. So even though they're telling you you have to have your application in order by a certain date, they're also going to tell you prior to that date you have to file a response. If you don't file a response to that, it does go abandoned. So it's, when you're docketing it, you should be docketing the response date that they're giving you for the first examiner's report, as well as the acceptance date.
Okay.
And then you will also get a second examiner's report if it's not allowed after the first one. Both of those, the examination reports, the first and second one, are extendable by 1 month. When you're docketing it, you should docket the response date that's provided from the examiner, as well as an acceptance deadline and a divisional application deadline. Divisional applications do have to be filed before the application is accepted. So that's something to keep in mind too.
So the big difference between Australia and New Zealand is that from a docketing standpoint, New Zealand also has additional deadlines to docket for responding to the examination report itself,
yeah,
in addition to the overall period for the acceptance timeline.
Yeah, exactly.
Okay, interesting. Oops. All right, South Africa. South Africa. The deadline for acceptance in South Africa is 12 months from the PCT national stage if you go into South Africa through a PCT application, or if you do a direct filing in South Africa, then the acceptance period is 18 months from the local filing date when you've done a direct filing. Both of those deadlines are extendable by 3 months, so giving you a total of up to 15 months if you're going off of a PCT, or up to 20 months if you did a direct filing. Now, the interesting thing about South Africa is that South Africa does not have a substantive examination of the patentability of the application itself. So the acceptance deadline applies only to the formalities. And typically, there is a deadline set for any formality requirements that may be issued by the South African Patent Office. Often that's a period of 6 months, which is then extendable. So two things that are different from South Africa. One is they don't have a substantive exam, but from the standpoint of comparing acceptance periods, the big thing that's different with South Africa is the acceptance period is calculated off of the filing date as opposed to calculating it from the date of the examination reports as you do in Australia and New Zealand. So you have to be careful what date you're calculating that from. Now, from a docketing standpoint, then, you need to docket the specific deadline for submitting the formalities if there is a formality requirement. Then also docket the acceptance deadline and a divisional deadline. And if so divisionals have to be filed before the application is accepted if you're going to file a divisional. And if for some reason you just aren't able to get whatever formality requirements you have taken care of and you have to file a divisional to continue to buy time to do that, and then you still haven't done that, in South Africa you can do yet another divisional application off the second one to continue to buy yourself time for those formality requirements. All right, Chris, can you talk about India?
Yeah. So India, the time period for acceptance is 6 months from the first examination report. It is extendable by 3 months with a fee. If it is not accepted, the nice thing is that it doesn't automatically get abandoned. And sometimes, and just in my experience, Indian associates are a little more laid back or lax as far as not letting you know if it was accepted by the acceptance date. There was a couple times I had to follow up with the associate multiple times because the date was coming up, and I'm like, something needs to be done here. Wow. And come to find out, they said, oh, no, we've got the response filed. Don't worry, you know, if it gets rejected, we'll get a hearing notice. And so then they'll tell you what the deadline date is for that. The hearing is mandatory, and if the agent does not attend that, then the application goes abandoned. Okay. So you have leeway from when that deadline, the acceptance period is, to it actually being abandoned. So as far as docketing, this is another one where I would say to use a reminder for sending instructions to your associate, starting 1 month from when you receive that examiner's report. And then also the acceptance deadline and the divisional deadline are the same date. So make sure you get both of those docketed as well. And like the other countries, divisionals can be filed before the grant of the parent application.
Now, 6 months, that's pretty fast. That's a pretty short window of time,
yeah,
to get the application in condition for acceptance.
Yes, this too is a change. It used to be 12 months, I believe.
Okay.
And so they've shortened it from that a lot, by half. So
okay, so if it's been a while since you've docketed for India, make sure you know that it has now changed from a 12-month acceptance period to a 6-month acceptance period.
Yep.
And then, Chris, you commented on, and our slides talk about that 1 month reminder date for responding or sending instructions to the agent, automatically rolling to the next month. And some this will vary depending on the docketing system that you use, but some docketing systems like Foundation IP will automatically move a extendable deadline forward. So if the deadline passes, the date hasn't been completed, the docketing system just automatically redockets it for the next month. But if you're working with a system that doesn't do that, make sure that you're going in and pushing that reminder date forward from month to month so that it stays in front of the attorney and on the attorney's docket, right? Yeah. Okay. All right, the last one is the United Kingdom. Probably the reason that most people thought the UK did not have an acceptance period is because this is just for direct filings in the UK. And quite honestly, I don't think in 20 years I ever did a direct filing in the UK. It's just not as common, certainly for us in the US, to do it that way. But if you do, the acceptance period is 4 years and 6 months, or 54 months from filing, or 12 months from the first examination report mailing date. So in contrast to India, where you've got 6 months to get this thing in condition for acceptance, the UK Patent Office gives you 54 months. So these things vary greatly in terms of the length of time you have in that period. And it's interesting in the UK that you have two different options, one that is calculated off the filing date, 54 months from the filing date, and the other that is 12 months from the mailing date of the first examination report. Now, I think there's a reason for that. Part of that is the UK Patent Office in some areas has a pretty large backlog. And as I understand it right now, you may not get an examination report within 54 months of your filing date. And in that case, then you'll get the other. You'll get the 12 months from the first examination report whenever that first examination report comes out. And in fact, the UK Patent Office wants everybody to have at least a year to put the application in condition for acceptance. So what will really happen is if that first examination report comes out in 42 months or less from the filing date, then that 54-month period will apply. But if it's beyond the 42-month date, let's say it's been 45 months or 46 months since the filing date, then the acceptance period is going to be 12 months from the examination report. You're never going to have less than a year. You're always going to get 12 months. Now, another thing from a docketing standpoint that you need to be really careful about and watch when you're dealing with the UK is that in under normal circumstances, a UK office action or examination report, usually allows between 4 and 6 months for the period for responding. But if you're working in that shorter acceptance period, if you have a 12-month acceptance period, it's not uncommon for the examination report to actually specify a shorter period for responding, often a 2-month deadline for reply, because the examiner knows that you're working in that shorter turnaround time. And I've talked to paralegals that have seen periods for reply as short as 1 month from the UK Patent Office. So make sure you watch carefully and docket the correct response deadline. So docketing tips for the UK: docket the specific deadline for responding to the examination report, and read that examination report carefully because that may vary depending on your period left for responding or for acceptance. And then docket the acceptance deadline and a divisional deadline. And I think I forgot to mention that the acceptance period is extendable by 2 months in the UK. So in summary, the acceptance deadlines need to be docketed in the following countries: Australia, New Zealand, South Africa, India, and Great Britain. Acceptance deadlines are concepts that attorneys and paralegals and docketers in the US are a little less familiar with because that's not what we're used to typically docketing. So be sure to take extra caution when docketing these deadlines because they can be tricky and they do vary from country to country. And it's a best practice to docket a reminder deadline in countries that don't set specific periods for responding to the examination report. And that will help you hopefully avoid the unnecessary expense and stress, and not to mention the potential upset client if you can't get the application in condition for acceptance, or you wait till the very end and have to file an unplanned divisional. Those reminders really, really help from a docketing standpoint with that. Okay, so I just want to remind everybody that you can submit questions using the Q&A button on your screen, and we'll allow a few minutes to see if we have any questions. I'm trying to see if we have questions. Hang on. Actually, Giles, I need to ask my moderator here. I'm not seeing the Q&A button box on my screen. Do we have any questions, Giles?
Yes, we have one question. I've recently docketed response deadlines in the UK with deadlines as short as 7 days because acceptance deadlines was approaching.
Okay, so that's a great comment, and it just goes to what I was saying as well. The examiners in the UK will adjust those deadlines. I've even heard of examiners in the UK faxing examination reports to people to get them quicker. Now, so those are short turnaround times, but the good news is, from what the paralegals that I've worked with have told me, the examiners really do make an effort to get the application in condition for acceptance in the UK Patent Office. And they are, once they pick up that application and they start working on it with you, they are trying to figure out how to get that done in that 1 year period if you're under that shortened period. So that's a great example. I appreciate that, that feedback. Gosh, I just don't know why I cannot see the question box here. Giles, do we have any other questions in the queue?
Yes, we had a few more. Is New Zealand the only country of these 5 where the DIV needs to be filed before acceptance, the others before grant?
Okay, so is New Zealand the only country where it needs to be filed before acceptance? No, I think actually several of them were, right? Australia was before acceptance, if I remember correctly. And New Zealand was, I think, South Africa.
India does. It's while it's pending.
Yeah, so most of them actually, it's the divisional has to be filed before acceptance as opposed to before grant. So it's an exception where it's anytime before grant. Most of them, and I think the safe practice is to consider it's probably going to be before, you need to file it before acceptance. Because if that application is not in condition for acceptance at the end of that period, typically then your application goes abandoned. And one way to think about it for all of us who are more used to U.S. practice, I like to compare it to the difference between what happens at the end of the 6-month period for a non-final office action in the U.S. versus what happens at the end of a 6-month period for a final office action or a final rejection in the U.S. If you have a non-final office action, you file your response before the 6-month date, but the examiner doesn't have to allow it. You wait and wait and wait and wait and wait and eventually get something back, but you don't have to take any action other than filing the response for a non-final U.S. office action. A final U.S. office action is a little bit more like the situation you have to think about in a acceptance period country. You file your response to a final office action in the U.S., and if that isn't allowed by that 6-month period, you got to do something. File a notice of appeal, file an RCE, do something, because otherwise it's going to go abandoned. So if you think about it like that and kind of compare it in your mind to what you have to do in response to a final rejection in the U.S., that might be a good way to think about it. Okay. Any other questions, Giles?
Is there a table that shows what countries collect back maintenance fees at the time the issue fee is paid?
Well, that's a good question. I don't have the answer to that because I wasn't looking at the allowance process. I was just looking at how you get it to be in condition for allowance. So I don't have an answer to that. Do you, Chris? Does maybe the PCT applicants guide have that type of information?
I would think that would be a good reference point.
Yeah, my best guess is, and if you look at the webinar slides from our last webinar, which was the third one in the series on formalities, I have a link to the PCT Applicants Guide. And the PCT Applicants Guide is a great resource in general. It has individual sections on all of the PCT countries, which it's not all of the countries, but most of the countries are going to be covered there. Mm-hmm. And that's the type of thing that I think might be covered in the PCT Applicants Guide. So I'd recommend you take a look at that.
Mm-hmm.
Looks like we have another question. Does South Africa use date filed or filing date as base date to docket acceptance deadline?
Say that again, date filed or what?
Or filing date as the base date to docket acceptance deadline?
Yes, and that's correct. So South Africa calculates the deadline off of the filing date as opposed to the examination report, which is different than most of the other countries we talked about here. But if you think about that, it makes sense. South Africa doesn't have a substantive examination. So there won't be an examination report. There may or may not be some kind of a formalities requirement that you get, but there won't be an examination report. So you don't calculate or use as the base date the examination report date because there isn't one. Instead, you use the filing date, and that's how the laws in Africa are set up to calculate it from the filing date.
Mm-hmm.
And that's all the questions that we have today.
Okay, great. Well, thank you very much. I just want to comment on the next upcoming webinar in our series. We have a webinar now scheduled for October 16th at 1 p.m. And note, that's a Monday. We normally do these on Wednesdays, but that's a Monday. And the topic will be the Unified Patent Court and Unitary Patent under the European System. So if you haven't been following the changes that have been going on in Europe, they later this year are implementing a unitary patent, which is a single patent that will be granted across all the EU countries. So if you don't like doing all those validations in all those individual countries, you're not going to have to do that if you are using the unitary patent. That's part of what they're doing. And then they are also implementing a unified patent court, which is a new system that's going to harmonize or unify the patent laws across Europe. So both of these things are going into effect either later this year or the beginning of next year. And I have a European patent attorney who's going to be here in Minneapolis with me, who is going to present on both the strategic considerations that you need to talk as attorneys to your clients about and things they need to know with the implementation of this unitary patent, as well as the docketing considerations for the paralegals and the docketing professionals that you need to be watching out for and taking into account as this changeover happens. So we're going to get the up-to-date information from a European patent attorney, and that will be on the 16th of October. So I encourage you to share this information with the attorneys you work with if they don't typically listen to this webinar, because this webinar will have information both for attorneys and for docketing and paralegal professionals. After that, we've had several requests for webinars on docketing. I don't have the dates set, but we're going to be announcing a series of docketing webinars soon. So watch our Black Hills IP website for details of a docketing excellence series, or a set of docketing webinars under the Docketing Excellence series.
Is that for trademarks?
Or yeah, for trademarks. Sorry. Thanks, Chris.
Yeah.
And then in addition to the docketing webinars, I just want people to know that we're also developing two other webinar series that may be of interest. One is an operations excellence series that will focus on the U.S. patent process. It will be particularly useful to U.S. paralegals and docketers, and also will be good for attorneys. It will go into things like, if I use as an example, let's say a notice of allowance. You know, what you do when you get a notice of allowance for docketing. You docket the deadline for paying the issue fee. But most people have quite an extensive process around a notice of allowance coming in where they're checking, did I get my all my initial IDS forms back? Do I need to file any continuations or divisionals? What are all those other things, the other operational things that happen at different points in the U.S. process we'll be talking about in that series. Then we're also working on an international excellence series, which will take an in-depth look at the patent process in different foreign countries, looking at things like the scope of protection in a country, the enforcement, how enforceable are your rights in the country, filing basics, prosecution basics. This will be particularly useful to attorneys in advising your clients on where you may want to foreign file. So I expect to have these laid out soon. You should see details coming in the next few weeks on the Black Hills IP website, and I anticipate we'll start them in September and do one a month for quite a while going forward, as well as continue the docketing series at about one a month for quite a while going forward. So thank you for participating today. We hope you'll join us for these and other webinars in the Docketing Excellence series and these other two new series that we're bringing on. And if you haven't joined our Docketing Excellence group on LinkedIn, please consider doing that as well. Thank you very much.